Good afternoon, everyone. To this session, I'm going to discuss about the privacy legislation. What is privacy legislation? Privacy legislation or privacy law is the body of law that deals with the regulating, storing, and using of personally identifiable information and personal healthcare information and financial information of individuals which can be collected by governments, public or private organizations or other individuals. Ang privacy legislation ay hindi tahasang nakasaad saan man sa Bill of Rights. The idea of privacy legislation ay actual na unang tinugunan bilang isang legal na konsepto na nagmula sa konstitusyon at karaniwang batas na ang mga tao ay dapat magkaroon ng pangkalatang karapatan sa privacy. Mula noon, nilikha at pinamamahalaan ng karaniwang batas ang karapatan sa pagkapribado sa tulong ng iba't ibang batas ayon sa batas. Privacy legislation relating to privacy can be broadly categorized into those laws which uphold the notions of privacy and protect privacy rights and those which tend to serve the interest of the state in the name of national security, crime detection, or counterterrorism. And as summarized in Figure 6.3, acts in the UK and US that relate to privacy. And in this section, we briefly discuss. Upholding the notion of privacy. The following two pieces of legislation set out in a concrete terms the value of privacy to individuals. The rights of personal privacy is implicit in the Fourth Amendment to the U.S. Constitution 1791, which states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person things to be seized. Generally speaking, the Fourth Amendment forbids searching private properties unless a judge or magistrate has issued a warrant. Mayroon ding exception kung saan ang ebidensya or ari-arian ay nanganganib na masira. Hindi kailangang magbigay ng warrant ang mga otoridad kung ang isang hinahanap na property ay inabandona or situated in an open field or plain view. Ang ilang mga estado have gone further than the Fourth Amendment and provided protection to open field properties. Seizure of property or ang pag-agaw ng isang ari-arian ay pinagbabawal din unless a warrant has been obtained. The warrant should list the property na kinuha ng mga otoridad during a search. Hindi maaring kunin ng mga pulisya or government force ang mga bagay na hindi nakalista sa warrant maliban kung ang mga ito ay nasa plain view at relevant sa investigasyon. The seizure of people requires a different approach by the authorities. First, the police officer who is going to carry out the arrest must be clearly authority. This can be shown by the carrying of handcuffs, commanding language, and appropriate force. Second, the person being seized must accept officers' authority and permit themselves to be arrested. To obtain a warrant either for an arrest or to permit a search, it will only be granted if the authorities show that it is necessary. Where the authorities ay maaaring magpakita ng probable cause, pagkatapos ay maaaring magbigay ng warrant. A judge or magistrate will look closely at why request for a warrant is being made before issuing one. Maaaring isagawa ang mga walang warrant sa paghahanap kung saan ang mga tao ay reasonable grounds or makatwirang batayan para sa paghahanap. Also, there must be no use of unnecessary force. Ang pagiging katwiran ay isang pangunahing prinsipyo ng batas because it applies to the Fourth Amendment. In framing the Fourth Amendment, the Founding Fathers were concerned with a basic human right, with the basic human right. The Human Rights Act 1998. Article 8 of the UK Human Rights Act 1998 also upholds the right to privacy, affirming that everyone has the right to respect for his private and family life, his home, and his correspondence. Halimbawa na lang sa nakita ko sa social media na ang isang hotel ay may mga hidden cameras na nilalagay sa bawat kwarto. Siyempre, makikita nila kung ano ang aton mga ginihimo, ang aton mga kiwa na mga ginihimo sulod dito nga room. So, dapat nire-respeto nila ang aton privacy. Siyempre, as a customer, hotel, as a human, we have a rights na magreklamo or mag-report regarding ito. However, part 2 of the same article goes on to state some important exceptions to this right. There shall be no interference by a public authority with the exercise of this right except such as in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. These are similar in most regards to the free-speech exemptions that we saw in the previous chapter. We shall see that many of these phrases appear in the Regulation of Investigatory Powers Act or RIPA. So, discuss it shortly. RIPA is the law that gives the UK government the right to intercept and view the private communications. The next category is protecting individual privacy. The Data Protection Act 1998, and this piece of legislation is particularly relevant to the IT professional because computer technology has made it much easier to collect, store, manipulate, collate, and disseminate personal data. Because of its importance, we have devoted Section 6.5 of this chapter to this act. The Freedom of Information Act 2000. According to the Office of the Information Commissioner, the Freedom of Information Act 2000 is intended to promote a culture of openness and accountability amongst public authorities by providing people with rights of access to the information held by them. It is expected that these rights will facilitate better public understanding of how public authorities carry out their duties, why they make the decisions they do, and how they spend public money. The Act creates two principal obligations for public authorities from which other obligations stem. 1. Each public authority must adopt and maintain a publication scheme setting out details of information it will routinely make available, how the information can be obtained, and whether there is any charge for it. The date by which public authorities are required to have their schemes in place varies. Public authorities should consult the timetable approval process to confirm the submission and the scheme active dates that will apply to them. 2. From 1 January 2005, each public authority must comply with requests for the information that it holds unless an exemption from disclosure applies. Public authorities will normally have a maximum of 20 working days to respond to the request. However, there are circumstances when this time limit can be extended. In the context of personal information, this act gives individuals the opportunity to find out from organizations what information is being held about them. As with the Human Rights Act, there are a number of exemptions to the provisions of the Freedom of Information Act. Various categories of information are exempt from disclosure, such as information which would prejudicially affect the sovereignty and integrity of the country, security of the state, strategic, scientific, or economic interests of the state, or conduct of international relations. Also exempt is information which would prejudicially affect public safety and order detection and investigation of an offense or which may lead to an incitement to commit an offense or prejudicially affect fair trial or adjudication of pending case. So last category is serving the interest of the state. The following two pieces of legislation have caused some concern with privacy and civil liberties groups because of their impact on individual privacy. Essentially, they give governments UK and US the right of access to personal communications, the Regulation of Investigatory Powers Act 2000 and the USA Patriot Act 2001. We'll now look at each in a little more depth. The Regulation of Investigatory Powers Act, or RIPA, was passed in July 2000. The act enables the government to demand that a public telecommunications service provides access to customers' communications in secret. The definition of public telecommunications service is broad and could apply to internet services providers, phone companies, or even someone running a website. Under certain circumstances, the Home Secretary can order the external communications of telecommunications services be intercepted. For example, all the internet traffic flowing through a particular ISP's machines, the Home Secretary can serve interception warrants to perform mass surveillance and can require ISPs to fit equipment that enables them to perform such surveillance. When ISP is served with an interception warrant, it has to comply and it may not reveal this fact to anyone ever. Under the Act, surveillance data that is obtained illegally cannot be used in legal proceedings. This means that were the government to illegitimately intercept an individual's communications, the data cannot be used in a court of law. The existence of surveillance data cannot be mentioned in a court of law, and that data cannot be used to provide evidence in the court of law. Overall, critics have argued that RIPA allows government to access a person's electronic communications in a highly unrestricted manner, thus impinging the privacy of their correspondence in a manner which many would not tolerate regarding their postal communications. The terms under which warranted interception is justified are sufficiently vague to permit electronic surveillance of anyone, under any circumstance. The state can thus gather information such as what website you visit and when, and who you email, who emails you, what news groups you read, and all the phone numbers you call, what software you have downloaded, and what documents you have downloaded, where and when you log on to a machine, and from where you log on. Others have questioned the restriction on the use of surveillance data in legal proceedings. The main object being that if someone has illegitimately been the subject of an interception warrant, there's no legal way for them to know about it, except through investigation by tribunal and very limited other circumstances. The USA Patriot Act 2001. The terrorist attack of 11 September 2001, the United States Congress passed the Uniting and Strengthening America by providing appropriate tools required to intercept and obstruct terrorism. USA Patriot Act of 2001. The Act expands the kinds of information that law enforcement officials can gather with the PIN registers, which devices that display phone numbers being dialed by a suspect, and trap and trace devices, which display the phone numbers of calls made to a suspect. It allows police to use PIN registers on the internet track track email addresses and URLs. The law does not require that probable cause needs to be demonstrated for the use of such devices. To obtain a warrant, police simply certify that the information to be gained is relevant to an ongoing criminal investigations. And that's the end of my discussion. Thank you everyone for listening.